going to do a very, very quick welcome before handing over to our speakers, and Caroline will kick off with the introductions for the speakers. Welcome to everyone in the room and welcome to everyone online. I'm Justin Briggs. I'm one of the disputes partners at Burges Salmon based in London. I'm also part of the LIDW strategy committee that organises the conference. Because of that, I have some strict instructions in terms of things I need to cover now very quickly. I want to thank everyone for coming today. There are over 250, I think it's something like 257 member-hosted events. That's events like this. So you've been spoilt for choice. My role on the LIW has been vetting those member-hosted events, not all of them. And so I know that there's a fantastic choice of things to go to. I'm under strict instructions to say thank you to our sponsors. That's the sponsors for LIDW. There you go. There's 24 of them. I'm not going to read out all of their names. If you don't know any of them, please do go on to LIDW website, click on their logos. That will take you through to their websites. Please find out more about them, what they do, and how they can perhaps assist you. LIDW simply wouldn't happen without their financial support. It also wouldn't happen without your support and attendance at events like this. So again, thank you from me. And in terms of LIDW itself, it grows and evolves. This is the 6th running. Last year, there were over 8,000 delegates. And yesterday, we heard that there are now over 9,000 delegates attending the conference. So that makes it by far the largest disputes conference in the UK and an event in terms of the global disputes calendar. That's everything from me. I'm now going to hand over to Caroline, I think, for intro of the team.
Thank you, Justin, and welcome everyone to the first of 2 panel sessions. Today is co-hosted by Burges Salmon and QEB Hollis Whiteman, and we are looking at managing complex disputes in the public eye. The second session is happening tomorrow, and that's going to cover the strategic use of tech and AI. So do come along to that if that's of interest. Today, though, we're focusing on balancing risk and demand across civil, criminal and regulatory spheres. Before we kick off, I'm going to first of all say some admin. There's no planned fire alarms, so if the fire alarm does go off, it's the real deal. Please follow the green signs or any Burges Salmon person and they'll lead you to the exit. The second admin really is to introduce the panels. If I can hand over to the 3 of you to introduce yourselves, that would be great.
Sure. Morning, everybody. My name's Andrew Matheson. I'm a partner in the Burges Salmon's dispute resolution team based in London and Bristol. I've got a dual practice spanning both civil and criminal law disputes. On the civil side, I specialise in international commercial disputes, often involving issues of civil fraud, and worked in the High Court, Court of Appeal, Competition Appeal Tribunal and Information Tribunal. And on the criminal side, I advise clients on issues of corporate criminal liability relating to offences including bribery, serious fraud, money laundering. And I've worked on criminal investigations involving the UK Serious Fraud Office, the US Department of Justice and the London Metropolitan Police.
Allison.
I'm Allison Clare. I think I know a fair few of the people already in the room. I've recently joined QEB. I specialise in white collar crime, including quite a lot of money laundering. And I would say most of the work that I do has a regulatory or civil crossover, but crime is definitely my sweet spot.
Hello, I'm Tom Broomfield. I'm also a barrister at QEB Hollis Whiteman, also specialise in white collar crime and fraud. I'm currently prosecuting an insider dealing case at Southwark for the Financial Conduct Authority, but I also do a bit of general crime and regulatory law as well.
And I'm Caroline Brown. I'm also a partner with our dispute resolution team at Burges Salmon. I focus on professional negligence, financial services litigation, and the management of portfolio litigation. So I'm going to get started on today's discussion, which is focused around the following scenario, which you'll see on the slide. We're putting ourselves in the shoes of the GC of a UK regulated professional services company called Deeds and Weep LLP. We have branches across Europe and we advise on non-UK property investments. And our unfortunate GC has received a letter from solicitors which details a number of civil claims from an investor or a customer of the business, including allegations around negligence, misrep and breach of contract breaches of the Financial Services and Markets Act, and even fraudulent conduct by the sales team in one of our European branches. So not a fun letter to receive, and that throws up a lot of issues. We're not going to try and cover absolutely everything today because we'd be here all day, and I'm sure you've got other events to get to. What we're going to do is think about the particular pinch points that will throw up between the civil, the criminal, and the regulatory. So to kick us off, I'm going to hand over to Andrew, who's going to think about what that GC is going to need to do on day one and the first response.
Thanks, Caroline. So at the outset, and at the top of this session, indicates you need to be conscious of whether your civil claim is going to bring with it regulatory risk or indeed criminal risk for the company. Now, as Caroline mentioned, our company is a regulated company, so it will, of course, certainly need to consider any regulatory risks arising in connection with the claim, particularly in light of the allegations of FSMA breaches and criminal conduct. Allison is going to speak, I know, a little to some of the considerations you might have when engaging with your regulators shortly. On the criminal side of things, I expect members of the audience will be aware of the growing legislative trend in the UK to make it easier, or easier in principle at least, to prosecute corporates for criminal offences, most recently via the Economic Crime and Corporate Transparency Act 2023. That legislation included a couple of key tools to facilitate the prosecution of corporations, both of which I'll touch on shortly. But the key point for you all to take away today is that the overlap between civil and criminal proceedings is one that I think we're going to see increasingly often, and is hopefully one of the reasons why this session is particularly pertinent now. So, as we said, our scenario involves allegations of criminal conduct by individuals, but those are going to be red flags for the company too. And I think it's worth mentioning two relatively new bases on which this scenario will result in corporate criminal liability for that our GC needs to address, both of which brought in under ECTA. The first is up on the screen, and I won't go into detail as I know most of you will already be familiar, but just to give a whistle-stop overview. Section 196 is a mechanism really for triggering what I might call primary corporate criminal liability. And what this provision says is that if a senior manager of a corporate or partnership acting within the actual or apparent scope of their authority commits a relevant offence, then the organisation is also going to be guilty of that offence. So the approach we have now in the UK is one that looks a lot like the approach taken in the US, where there's almost a form of vicarious liability used for attributing corporate criminal liability. Just a couple of points to unpack here. Who is a senior manager? The legislation gives a very wide definition. It says that a senior manager will be an individual who plays a significant role in either the making of decisions about how the whole or a substantial part of the organisation's activities are to be managed or organised, or an individual who plays a significant role in the actual managing or organising of those activities. So this is new legislation, of course, and that definition hasn't yet been tested in the court, but it's going to extend well beyond those at board level in most cases. So this really is going to create a real risk point for corporates in cases of at least alleged employee wrongdoing. What is a relevant offence? Well, at the moment, the senior manager test is only triggered by the commission of what are described as economic crimes. So we're thinking about fraud, bribery, sanctions and export offences, offences under FSMA, and money laundering. But there is a new crime and policing bill currently before UK Parliament, which is proposing to extend the senior manager regime to cover all criminal offences. The second basis on which this scenario might give rise to criminal risk for our corporate is via the new failure to prevent fraud offence. So this offence is not in effect yet, but it's coming in September this year, so in just a few months, and it can be committed by quote unquote large organisations as defined in the Act. But boiling it down to its most basic form, there are three key elements which we've got up on the screen here. So first, you need someone to have committed a fraud offence, and fraud offences are going to include all the general fraud offences under the Fraud Act: false accounting, false statements by directors, fraudulent trading, and obtaining services dishonestly. Second, your fraudster needs to be an associate of the organisation. And in this context, an associate can include employees, agents, subsidiaries and your subsidiaries' employees, and indeed anyone else who performs services for or on behalf of the organisation. And finally, your fraudster needs to have intended to benefit either the organisation or a person to whom they provide services on the organisation's behalf. A quick word on extraterritoriality. This is London International Disputes Week. Both the senior manager regime and the failure to prevent fraud offence can expose non-UK corporations to criminal liability if there's any UK nexus to the underlying relevant criminal offence. Finally, on the criminal side of things, I think it's worth mentioning that the letter of claim should also be raising red flags in relation to money laundering and questions of whether the company holds any criminal property, and if so, what it needs to do about that. And again, I know Allison is going to touch on that shortly. So, having identified the need to manage your risks across regulatory sphere, civil sphere, and criminal spheres, I just wanted to touch very briefly on some practical considerations for our GC on day one. First up, our GC just needs to have a think about who needs to be involved and assemble the right team to manage the claim and likely subsequent investigations. Have a think about who in your legal team needs to be involved, commercial and operational teams. You will almost certainly need somebody from your IT or tech team, if you have one. And also have a think about communications with your clients, regulators, and perhaps even the media and the public at large. Similarly, have a think about what external advice you need. Make sure you've got the right legal cover. Burges Salmon and QEB Hollis Whiteman are very good at this, but other good firms and barristers' chambers are available too. Given the international element, have a think about whether you need overseas local advice from on this too. Have a think about external support on IT and tech, and perhaps even on communications. I'm going to pass over briefly to Caroline to talk about document preservation and some common pitfalls.
Thank you. So document preservation, another point in this is that our GC is going to need to engage with early on. Any UK lawyers in the room will be painfully familiar, I think, with the obligations imposed on them around disclosure, but it is something that can take parties to litigation unawares, and particularly the early stage that it kicks in and the proactivity that's needed. So what are the obligations and why they're important? What happens if you ignore them? We're obviously under an obligation here to take reasonable steps to ensure that all relevant documents are preserved. And we need to do that as soon as we're on notice that there's a potential claim that litigation's in contemplation. So we need to take action quickly. And the reason we need to do that, because if relevant documents have been destroyed and that's discovered later, then we're going to need to explain that to the court and to our opponent. There'll be adverse inferences drawn about why those documents are no longer available, and there might be sanctions applied. Usually those will be cost sanctions, but if there's an extreme example or there's no clear explanation of why documents have mysteriously gone missing, then there may well be personal sanctions as well for those involved. The other point that can take people unawares, and particularly people who aren't familiar with civil litigation, is that the breadth of what's covered by the term document. It's not just your emails, it's not just your formal written notes. It's a record of any description containing information. So that can take any form. It can be paper, electronic. It can be your emails, your formal document files, your social media, your metadata, your voicemails. So a lot to unpack there. We also know from the scenario that this is a significant multi-issue case with a lot of strands to it. So we can expect a large volume of documents from numerous different sources. That means that our GC is going to need to work with their lawyers to conduct an early data mapping exercise. What are the relevant documents? What are the issues in the case? Where are the documents and how are they stored? That's going to need to be done in conjunction with lawyers who'll be able to identify the issues in the case and think about what relevant documents there will be. It's worth noting, just a quick plug here for our Thursday panel tomorrow, which is going to look at AI and legal tech and how that can help with data mapping and document analysis. So if that's up your street, do come tomorrow as well. Andrew's mentioned the involvement of IT teams. They could always help with ensuring that your deletion and destruction processes are suspended so that documents aren't inadvertently lost. And we'll need to notify employees, former employees and third parties to make sure that they're on notice of the need to preserve as well. So fairly onerous, and a lot of actions that our GC and their legal team are going to need to address. But there are some advantages of looking at this early on. It's going to help you map out the case that you're dealing with. It could help you think about who your witnesses are going to be, what sort of issues you're facing. And if we know that the claimant who's made a claim so far is complaining about something that we know to be systemic within our business, we can think about, well, what other claimants might come forward? What sort of losses are we actually looking at, this claimant aside? So it can help us plan and manage the litigation more proactively. So that's the civil aspect, really. I think, Andrew, did you have some additional thoughts on the criminal side of things?
Yeah, I think given time constraints, you'll be pleased to hear we won't get into the weeds of specific document preservation obligations. But I think the practical point on day one is really that it's sensible to cast your document preservation measures as widely as possible, because, of course, on day one, you're never going to be quite sure what will and will not be relevant as the litigation or an investigation develops. The final point we've got up here as an initial consideration is to have a think about who needs to be told about the claim. That might be your insurers, that might be your customers, it might be a regulator, and it might even be the criminal authorities, which presents me with a nice segue to hand over to Allison.
Thank you. So my sections, as you can see from the screen, what do we tell the authorities? There should probably be a bracket after that, if anything. And if you were, Andrew, were dealing with day one, then if you're considering self-reporting early engagement, that's probably day 1 to day 365. So it's obviously not something that is happening right at the start of a process. The authorities, just one point to add to first of all, to what Andrew was saying, bearing in mind what our scenario is about the failure to prevent and large organisations. Just to add in on our scenario, it also does apply the offence to smaller organisations who are a subsidiary of a large organisation where the alleged fraudster is an employee. So please don't think large organisations that's the be all and end all. If you are a subsidiary of a large organisation and it is your employee who has committed the fraud, you can still commit the failure to prevent offence. And I think in this perhaps smaller financial services firm that we're talking about, it's a really important thing to remember. Anyway, back to my own section. So obviously, the authorities generally, whoever they may be, whether you're talking about mandatory reporting obligation and perhaps more importantly here, a voluntary one, they're obviously very keen on self-reporting. That's why we've got a whole section of new guidance issued by the SFO, which I should think most in the room are familiar with. We've also got the CPS, obviously had their first own DPA with Entain, and they've certainly, or somebody has leaked the early plea negotiations that they've offered to individuals in that case. So it's not just the SFO who are making waves in this space. You've also got to be considering other authorities. But self-reporting cooperation, I'm sure I don't need to tell most of the people in this room, requires some very careful thought. And if I was the GC of this fictional organisation, I would basically be asking myself 3 fundamental questions on day 2 onwards, which is firstly, what exactly is it that I'm thinking about reporting? And it sounds like a simple question, but it's a really fundamental part of the consideration in this area. Secondly, do I actually have a choice? Legally, practically, because that will run alongside the first question. And thirdly, if I do have a choice, is it really what's the end game? Is it going to is it worth me considering reporting? So the first question, which I think is really fundamental, is what exactly is it I am reporting? You obviously should not be thinking about knocking on anyone's door until you've got a fairly good idea of what your exposure is to criminal liability in terms that Andrew was talking about, to what authorities and in what jurisdiction. And that is not something I don't think that anyone can sensibly know in the first few days of the scenario that we've been asked to consider. And the new SFO guidance is realistic about that, I think, because it accepts that there has to be an early investigation, I think its phrase is, in order to understand the nature and extent of the offending. In the longer term, if you made a decision to self-report, the authorities are going to be want to set the parameters, I think, of the SFO's phrase, of the more detailed investigation. But obviously you can't really have a sensible discussion about what those parameters are unless you yourself, before you knock on anyone's door, have a fairly good understanding of what your potential exposure is. So that initial investigation really needs to be thorough enough for you to understand your exposure. But it also, I think, if you feel you are driven to knock on somebody's door, it allows you to set the appropriate tone and content of any self-report, which I think is really, really key. Because if you are going to make a self-report, and obviously in some situations, probably this one, you don't have a choice because you're a regulated firm, you want to be confident that what you're saying in those early days of reporting is going to hold good for the long term. Because the last thing you want to bring upon yourself is a retreat from the basis upon which you made that initial report. In short, you don't want to take any duff points as part of that initial report if you decide to make it. So you want to be confident that the authority can be confident in you and the quality of your initial report. So don't knock on anyone's door unless and until you have that level of confidence. So that's the second question. The first question, understanding what it is you are actually reporting. The second question, which runs alongside that at the same time, is do I actually have a choice? And I think there are probably 3 areas on your GC's list to consider when assessing whether you actually have a choice. But the first one is legal, the second one is factual, and the third one is just a practical point. So legally, fundamental question, do I have a mandatory obligation to report to anyone? And I think importantly, not just about the main offending, and I think that is a really important factor to bear in mind, particularly on the scenario that we have, because obviously we have a regulated firm, so there is a freestanding regulatory obligation which you're going to have to manage. But do you also have mandatory obligations or de facto mandatory obligations under the Proceeds of Crime Act? Because if you have a fraud offence, you almost certainly have some criminal property somewhere in the scenario. And that could mean, firstly, if you're a regulated firm, you do have a mandatory obligation. And if you want a defence against your dealing with that property, then you have to apply for a defence against money laundering SAR. And I think, not something I often say, but POCA can be your friend, I think, in this situation, because I can't believe those words came out of my mouth, but they genuinely can, in my experience, because if the fraud which you can see on the radar is fairly confined and you have a pot of criminal property that you can ring fence, then there could be a workable solution which might be able to resolve it under the civil POCA powers. So it's really worth thinking, POCA not just as a source of pain, but whether it could actually provide a route, depending on the factual scenario that you have, could it actually provide quite a workable solution to the fraud that you think might be on the horizon? So that's the first. Legally, do I have a mandatory obligation? In which case, in a way, that the next step, or the initial next step, is an easy one. But secondly, there is a factual aspect to whether really you are forced to report. And that something I'm sure you're all very familiar with, but is this news going to be out there in any event fairly shortly? And do the authorities already have a good deal of this information? Because if that's the case, then obviously you've got a fairly good incentive to get your account in first. And the third aspect of do I have a choice, I think, is really a practical consideration, which is even if I have no legal obligation, and I don't think the news is out there, although in our scenario, there's already a civil suit, so at some point it's going to be, is the conduct which I am now on notice of or about to investigate of a type where it would be pretty disastrous for my company if I did not make a self-report? And that obviously is a judgment call depending on the facts of your case. But I'm thinking in particular of the Amec Foster Wheeler DPA and what was said in that, which was the judge in that case, probably a while since you've all read it, but the point he was making was even absent a mandatory obligation to report within the company, he was, I think, not a phrase he used, but he found it pretty galling that having not reported that, you're now coming along and asking for a DPA. And his point was, I'm only allowing it in this case because there's been two takeovers of this organisation since. But if you'd been coming to me in your original form, I would not have been giving you a DPA. And the point that he was making was, don't just worry about legal obligations. Have you got an ethical corporate governance obligation to report? If you have, it's pretty cheeky to then come along and ask for a DPA unless you've got some pretty exceptional circumstances. So that's the last practical consideration in do I have a choice? And that will depend on the conduct and the scale of the conduct probably that you've got as part of your self-report. So the final point on choice is this one, which I think is a really interesting point in the new SFO guidance is, if you do decide you've got to report to somebody, what do you do about everybody else? Do you make voluntary reports to other organisations? Now, what the new SFO guidance says is a report to the NCA, a report to the FCA is not a report to us. And they set that out quite clearly. But I think you do have to wonder, or I am going to wonder, whether that part of the guidance is pretty aspirational. There is obviously turf war is a bit strong, but various authorities want to have primacy in terms of investigations. And certainly in my experience, the touchstone is really the reality of your cooperation, not who reported to who when, particularly when there is at least a report to somebody. And I certainly think, in my experience, that particularly if there's a mandatory reporting obligation, one report is often the best advice, even though the SFO guidance says that will not tick the self-report box for us. So third question, once you've been through what am I reporting and do I have a choice, is it going to be worth it if I have a choice? The pros of considering if it's voluntary telling the authorities, well, lots of them are obvious. I think the one that is much more prominent now than it probably was 10 years ago is reputation, which obviously I think companies are much more alive to now as being towards the top of their list than previously. And I think the second important pro, which is really practically important, is it gives you locus in this process. And I think that is something that can't be underestimated. And I think particularly in those cases, it's hard to tell from our scenario whether this is one of them, whether you actually have some fairly powerful counterpoints to the allegations. So if there is a prospect that by moving on the front foot, you can write to the FCA, you can write to the SFO as a piece of advocacy, if that's not a dirty word, to say, well, I can tell you why you don't actually need to investigate me. A, because I'm self-reporting, and because I'm pointing out to you that whatever the allegations, these are the reasons in the circumstances of this case why you don't need to take it any further. And that is a really, if you've got that opportunity, then I think it's obviously one that's worth taking, because all these authorities have resourcing issues. And if you can present a logical and reasonable off-ramp, a lot of them are very interested in not investigating you. Obviously will depend who your corporate is and what the alleged conduct and your counterpoints are. So if you can't persuade them not to investigate you, then you're also going to have to consider, well, might a DPA be the best resolution for me in the circumstances? Obviously, we know that in some cases, so in Glencore, there was a plea resolution. In other cases, there's been DPA resolutions. But I think in the current climate, the value of the DPA is coming into sharper relief as opposed to a plea agreement. And I say that because of the prevalence now of subsequent civil proceedings following, or not even following, as Tom's going to deal with, but at the same time as criminal or regulatory investigations. Because I know all of you will know this, but it's worth underlying, a DPA does not involve an admission of guilt. Now, I know there is a very fine line, particularly when you read some of the statement of facts, which look a lot like an admission of guilt to me, but I think, time has moved on as to how they are prepared now. But it does not involve an admission of guilt. So in terms of subsequent civil proceedings, it's not quite such an easy knockout blow for the other side, as opposed to a criminal plea as part of an actual prosecution. So I think it's worth bearing in mind, particularly for that reason, whether a DPA is something that will be of use to you. The cons of self-reporting in any form, I think probably we're all familiar with, and I'm not going to go through the obvious ones, which is the cost. It's never as quick as you think it's going to be. LPP, authorities conducting their own investigations, we're all familiar with them. But I think that there are some more nuanced aspects of not self-reporting, against self-reporting, which have come to the fore recently. And I'm just going to talk about two of them. So the first one, paradoxically, I think is the new lower test of corporate criminal liability. So the SFO have campaigned for this. One assumes, therefore, that they have to be seen to be using it and prosecuting the senior managers that Andrew was talking about. But if the authorities use that new power correctly and use the DPA powers correctly, I think it does lead to a diminution in the value of the DPA process, because what should happen legally, which is of course not always is what does happen, is that it should result in DPAs offered to corporates really being about substantive offences, not failure to prevent offences. Because if your senior manager is being prosecuted for fraud, as may happen in this scenario, then the corporate DPA should be for a substantive fraud offence. There should no longer be allowed the bifurcation between the failure to prevent and the substantive offences. And it goes without saying that a DPA for a substantive offence is a lot less attractive proposition reputationally and for all sorts of other follow-on reasons than a failure to prevent offence. So I think, controversially, paradoxically, lower test of corporate liability is not a good thing for DPA resolutions, actually. And I think that the second thing, which I touched upon a moment ago, and this is the last area that I want to talk about, is the prevalence now of civil proceedings on the back of or alongside the criminal investigations. And I know Tom is going to talk in a minute about the use of civil material in criminal investigations. But I just want to flag as my sort of point against self-reporting generally is the use of material generated as part of the criminal investigation against your client, the fictional LLP, in civil proceedings. And by that, I mean not pre-existing material, but material that's actually generated as part of the criminal investigation. So Section 2 interviews, PACE interviews, whether it be of witnesses or people who end up being defendants. And the uncertainty is created, I think, because used material in a criminal prosecution is not subject to an implied undertaking, not to be used for another purpose. So anything used, you are going to have got from the SFO, and your opponent in the civil proceedings will be able to get from you, assuming it's all based on the same facts. But when it comes to unused material, the situation is much less clear. And so when you're going into this process, it's very hard to advise your client what's going to happen in relation to that unused material. And that's because although unused material is subject to an implied undertaking, it can be lifted. And we know there's lots of whiz-bang ways in the civil sphere that confidentiality can be preserved to a certain extent. Although if your opponent's got it, I would have thought that's pretty cold comfort in any event. So implied undertaking can be lifted, but I think the real area of confusion is when the SFO provide information in the early days of the grey area, which is this a DPA? Am I starting an investigation? Am I thinking about prosecuting you? So when the status of those proceedings is up in the air and the SFO provide you as the person being investigated with material, in my experience, they're not always very clear about the basis upon which they are giving you that material. So use of the word disclosure, I mean, never is a word more sort of abused, i.e. it's not being given in its legal sense. Very often you're being given material to say, well, hello, as the SFO, I'm going to show my hand to you. I'm going to show you a precursor of what the case is against you, as set out, for example, in an interview, etc. So it's not in final form, but this is what you're facing as part of that investigation. What actually is the status of that material? Is it used material? Is it unused material? Because that really matters to you as somebody who is looking at the prospect of being civilly sued on the basis of the same conduct. So I think that whole area of collateral use, you've got to be asking yourself, if I'm self-reporting, am I actually generating material which is going to be used against me in the civil suit? I mean, putting it shortly. And I think that additional uncertainty is a real con at the minute.
Well, as Allison just mentioned, she's spoken about the use of evidence from criminal proceedings in subsequent civil actions or civil actions that are going on at the same time. Looking at the reverse, so evidence from civil proceedings can, in certain circumstances, be used in a subsequent criminal case. The governing provisions, I'm sure everyone knows, are CPR 3122 and 3212, which confine the use of documents disclosed and witness statements served in civil proceedings to those proceedings unless they were read by the court or put in evidence in a public hearing. So that's the first exception. The court's permission is obtained, that's the second exception, or the disclosing party or the author of the statement agrees to it being used. And we often see evidence from civil proceedings being used, or at least being sought to be used, in private prosecutions that are based on the same or related facts. Now, the relationship between concluded or parallel civil proceedings and a private prosecution throws up all sorts of issues about mixed and oblique motives that we don't have time to go into today. That could be a whole talk in and of itself. A smaller example, perhaps, comes from my current ongoing trial at Southwark, where the first defendant provided a statement to the immigration tribunal, which contained an inconsistent account to the one that he gave in evidence in his criminal trial. And that statement that was provided to the immigration tribunal was used against him by a co-defendant because it had been used in a public hearing in the immigration tribunal. And so that just underlines the importance, sort of going back to our scenario, and the GC's advice to any significant actors within the firm, of maintaining a consistent account in relation to all of the different sets of proceedings that might follow. When it comes to, well, you have lots of different sets of proceedings. When it comes to who goes first, there are no hard and fast rules about which case takes priority, and it will often depend on the particular circumstances. The trend certainly used to be that a criminal prosecution would take precedence and everyone else had to wait. Unless, such as in LIBOR and EURIBOR, there was a relatively swift regulatory action against the corporate, which precipitated a criminal investigation into individuals. The public interest in preserving the integrity of the criminal proceedings often trumped everyone else. And certainly that was the case in Barclays, which is one of the cases I've mentioned in the slide. I'm sure everyone's familiar with the facts. Barclays' failure to disclose full details of the side agreements with Qatar in June and October 2008 led, first of all, in 2013 to the FCA beginning a regulatory investigation, and warning notices were issued in September 2013. Those proceedings were then stayed because the SFO started a criminal investigation. That rumbled on for about 3 years. And then in January 2016, PCP Capital Partners brought a civil claim against the bank for fraudulent misrep. But then in June 2016, so about 6 months later, the SFO charged the bank and senior executives with conspiracy to defraud. Now, that led to a contested application to stay the PCP proceedings. And in those circumstances, the governing provisions are CPR 312G and Practice Direction 23A, which relate to a stay of civil proceedings where you have a determination of criminal proceedings pending. And the key authority, which I've put up on the slide there, is still Snorrison and Tonov, a 2013 case, which stated that the defendant must point to a real and not merely notional risk of injustice if civil proceedings continue. But even if the court is so satisfied that proceedings should not be stayed if sufficient safeguarding against the risk of injustice can be imposed. So in this instance, in PCP, the court granted the stay and then permission to appeal it was subsequently refused. And I'm sure we all know what happened next. The charges against the corporate were dismissed, and then the SFO failed to get a voluntary bill of indictment. And then the case against the individuals was stopped at half time. That was partially successfully appealed. And then they were all acquitted on the 28th of February 2020, my note says here. And then that allowed the PCP claim to start, and that resulted in a win for PCP on liability, but a failure on causation and loss. And then finally, the FCA, which started the whole thing, picked up their regulatory enforcement action against the bank, which had been stayed since 2013, and that settled in November of last year. So in that example, the criminal proceedings took priority and civil and regulatory actions against the corporate were stayed pending the conclusion of the criminal proceedings. Significantly, though, although the FCA's regulatory proceedings were continued against the bank only, individuals who were still wrapped up in the case were still affected by them. So John Vardy, the CEO, was summoned to give evidence at the upper tribunal hearing, although he never had to go because the case settled. And one of the criminal defendants had an application to be authorised by the FCA, recently refused, partly because of some dishonest answers he was found to give an interview about the Qatari fundraising. A more recent example that bucks that trend, which I think we might see more of, is London Capital and Finance, where there is a SFO investigation into the executives that has yet to result in any charges. But as of last year, in February 2024, I think with judgment on the 14th of November 2024, the administrators won their case against some of the executives, I think all of them, in fact, that may be on the investigation, I don't know, in a civil case. And so in that example, the civil proceedings have taken the lead, presumably because the administrators didn't want to wait to get the money back for the creditors. And although the civil proceedings found a number of the executives liable to LCF for their knowing part in the fraudulent conduct of the company. As I've said, none of the execs have yet to be charged by the SFO, although the CEO has been issued a 10-month suspended custodial sentence for breaching his restraint order. So although the SFO and the FCA now are keen to trumpet how the speed of their investigations has picked up, I think we're likely to see more examples like London Capital Finance, in which civil claimants successfully resist applications to stay or just manage to get their case on first. And that's principally, I think, because of the backlog. And, well, that's at least one of the reasons. And the ludicrous amount of time it's currently taking for criminal trials, particularly complex and lengthy fraud trials, this the Southwark Crown Court, to be listed. I've got a PTPH in a relatively lengthy fraud trial that's happening at Southwark on Friday, and no one's expecting that case to be listed before 2028, to give you some idea. So if you're a civil claimant and you're faced with at least 3 years delay, then I think we're going to see this trend continue, and criminal proceedings, in fact, following civil proceedings. So I think now Caroline's going to trot through some of the type of civil claims that might arise in our scenario.
Yes, thank you. So as Tom has said, we will often have civil claims going first. So to bring us back to our scenario and the start of all of this, what are the civil claims that our firm is facing? What does our GC need to deal with? What sort of impact are they going to have? And how can we manage those tactically and strategically? And what's a difficult and multi-issue piece of litigation? So the claims that have been asserted are negligence, misrepresentation, and breach of contract. And we don't know the details. We don't need to for the purposes of the discussion today. But we do know, I think, that the breadth of those allegations, the criminal angle as well, the regulatory angle, is going to attract publicity, and it may well attract other claimants. So whether those are other customers of our firm who might not be aware that there's an issue and have been alerted to that and start thinking about bringing their own claims, or whether it's others, so creditors of the firm who can see that we're in trouble and want to protect their position by calling in their debts or taking other action. We could compare the situation that Deeds and Weeps finds itself in with a lot of the high-profile collapses of volume claims management firms that we've seen recently in the UK. So the SSB Group, Axiom Inc, Pure Legal are all examples of that, where we've had high-profile litigation, multiple strands of actions going on, and quite a lot to deal with. So thinking about that scenario, and if I start with creditors of the firm, one thing our GC is going to need to be alive to is the prospect of a creditor taking what could be a quicker and easier route towards a winding up petition and compulsory litigation. If we've got an undisputed debt that we haven't paid, then a creditor might seek to exert some pressure through that route, and that would need to be engaged with pretty quickly by the GC. It obviously brings to bear significant pressure. A liquidation would be the end of the company, effectively. It could also result in a liquidator investigating the affairs, so bringing to mind that regulatory aspect as well, looking at the conduct of directors, whether there's been any misfeasance or misconduct or misappropriation of funds. So we'd also then need to think about whether the GEC needs to think about independent legal advice for those directors, and bringing that into the scenario as well. And then thinking about the civil claims that we're looking at: professional negligence, breach of contract, and misrepresentation. Professional negligence and breach of contract will often go hand in hand, and those will obviously give a remedy against the firm. So if there's a negligence claim that's been asserted here, we'd need to think about, well, what's the duty of care that we might be owing our customer? Have we fallen below that standard of care? Have we breached that duty? And if so, has that caused them to suffer some loss? Is there any defence that we've got? Is there a limitation defence? Are they out of time to bring a claim? If we've been giving advice or working for them on an ongoing basis, does that complicate the limitation position? That will often go hand in hand with a breach of contract claim. So here we know that it's the European branch that's caused some issues. So what are the terms of the contract between us and our customer? Are they governed by English law? Is there another jurisdictional angle here that we need to think about? And could that give us a way out, a bit of wriggle room of defence, or a way to complicate matters and make it more difficult for the claimant? And again, is there a limitation position? Is there a limitation of liability in that contract? So lots of things to think about. Both of those claims will give a remedy of damages against the firm, and that will be aiming to put the claimant in the position they would have been in had the wrong not occurred or had the breach of contract not happened. But where we're looking at a misrepresentation claim, or where we're holding funds on behalf of claimants or customers, there could be another angle which could lead out to routes towards directors or others. So that's something, again, that the GC is going to need to think about. If, for example, a claimant is asserting that they've entered into a contract with our firm on the basis of a fraudulent misrepresentation, then it might be an option for them to rescind or unwind that contract as if it had never happened, and to give them then a proprietary claim against funds that they've paid to us as a result of that contract. And that could then lead to some tracing of those funds out through the firm and to a director. And similarly, if we're holding funds on behalf of claimants, then do we have a fiduciary relationship of some description? Are we holding funds on an express trust or as an agent? Or could it be that if we've misappropriated funds in some way, obtained them through fraud, then there could be a constructive trust implied there? And again, that might give rise to a proprietary claim and a tracing action through the firm and out to directors or even other third parties who receive those funds, depending on what exactly has happened. So the director will need to think about multiple strands there and whether there's any proprietary claim that could arise, and whether, again, those directors need to have independent legal advice as well. All of that is going to increase the pressure, and that's just thinking about the civil aspect. Obviously, this is only one part of what's a really complicated scenario. I've mentioned attracting other claimants and publicity that could generate. So we might need to think also about group litigation and class actions as well. We know that that's on the rise in the UK. Group litigation around product liability, about financial services, ESG, and data breaches. And that can take multiple different forms. We could have a single claim form dealing with multiple claimants, or we could have a number of claims that are being consolidated and are being dealt with together. And that's going to sound intimidating, stressful, expensive, and time-consuming. But as a defendant, query whether that might have some advantage to us in some way. So if we know that one claimant's asserted a claim, but there may be others in the pipeline, could consolidating those claims give us a little bit more control, a bit more knowledge over how many claimants we're dealing with, the amounts at stake? Bringing it all together could give us a little bit more certainty and prevent things coming out in a piecemeal way. It would also potentially mean less management time for us. We'd avoid a situation in which we've got one claim approaching trial, another one pre-action, and multiple others in between. So helps a bit with managing the project overall. And in terms of tactics of how best to deal with that, I'd say this, and I'll come to this when we're wrapping up as well, needs to be looked at as an overall big picture, as a project. So thinking about how do we not be seen as an easy target? Thinking about any decisions that are made in one aspect of the litigation that's going to affect others. So if we're settling claims early, is that going to give the impression that we're an easy target and will bring other people, will encourage them to bring claims? Or does it mean that we're getting rid of them early and balancing that against the risk and the cost of continuing to defend them? And thinking about what Tom and Allison have just said as well around, well, if we're making any decisions on this civil aspect, how is that going to play out later in any criminal or regulatory sides as well? What decisions are we going to make that could impact later on? And again, where you're dealing with multiple claimants, making sure that you're still assessing each claim properly on its merits, not letting any weaker claims get bundled up with stronger claims, and letting weaker claimants kind of through the door just by virtue of the amount of issues that we're having to deal with. So keeping in mind the big picture always. And I think then that brings me to some conclusions really on how strategically we can bring all of this together and manage it proactively. And I'll ask for some comments from the panel as well on this, but I'd say this really comes down to, this is a big legal project to manage. So project planning is key. Before we're diving in and reacting to this letter that we've had that's raised a lot of issues, taking a step back and thinking about how are we going to manage this. So establishing your team early, formulating a really clear reporting structure, having one senior point of contact at the top who will have overview of everything, Who needs to make the decisions? If you've got really critical decisions, being clear about who's going to sign off on those. If there are more day-to-day decisions, who lower down the chain can think about those and sign them off to prevent clogging time and costs at the top, and making sure that you have a process in place for your timetable of reporting. How frequently are the client and the legal teams going to report to each other? How often are the different work streams going to report to each other? And making sure that there is oversight generally on all those work streams, so that, again, we don't have an inadvertent negative impact of one that's been made as a domino effect of a decision made in another. And that also will help avoid your inconsistency. It will help reduce your management time and cost burden as well, and ease the pressure on our GC, who's facing an awful lot of issues to deal with. I'm conscious of time. We're nearly at an hour. So I think it falls to me then to invite some final thoughts from the panel. I know Andrew's got some around that strategic management.
Yeah, unfortunately, I think you've slightly nicked my final thought, Caroline. So we'll meet our time. But what I really wanted to just stress is I think it's quite hard to overstate the importance of ensuring that there's proper and regular communication between what are usually separate teams advising on civil, criminal and regulatory. We've been working with a client recently who is subject to a criminal investigation, but is also defending parallel civil claims, and just for good measure is also involved in a very public inquiry. And we've been working with another firm who've been managing the civil side, and it's been so useful to be having regular catch-ups so that we know if, for example, concessions or admissions are being made in the civil claims, what's the impact going to be on the criminal side of things, and vice versa. The civil team obviously are keen to know what's happening in the criminal investigation. Is anything about to be made public? So as ever, civil litigation and criminal investigations and prosecutions have their own distinct life cycles and pinch points. And especially corporate clients' priorities are bound to evolve during that period. So you really need to make sure you've got somebody with a steady hand on the tiller to make sure that the left hand knows what the right is doing, if I'm not using too many hand metaphors there, and just to make sure that you're striking the right balance between those competing spheres.
Sorry for stealing
Don't
your point. Allison, Tom, any final thoughts?
Yeah, well, I'll just go back to my point about the backlog. Really, I think that's going to have a continued effect in the years to come, despite any efforts from Leveson that will be published any day now to try and sort that out. I don't think they're going to make much of an impact. So that will, I think, continue to sort of dominate how these cases are ordered and how they play out in multiple different legal jurisdictions.
I think my final thought is once you know what's what, is to really give some serious consideration to whether civil forfeiture, making POCA potentially your friend, actually might be a very practical solution, depending on the facts.
Thank you. We are at an hour, I think, so we won't take questions from the floor, but I think there is going to be a lunch, and very welcome to come and collar one of us. No pun intended on the white collar crime aspect. If you've got any questions, do come and grab us during lunch. And thank you very much for coming along today.